Gosh, Alex, I'm so glad you started with that question because it's not exoneration. Exoneration would be Donald Trump going to trial and a jury of his peers finding him not guilty of the charges. He's already tried that in New York, and that didn't work, right? So, no, it is not total exoneration. Just the reemphasis of what's going on here is the absolute immunity for a president. That is not a new or novel concept that has always existed. It's just the kind of expansion of something called presumptive immunity, this idea that now some of the conduct of a president while in office is going to get the cloak of the protection of immunity until and unless we can kind of pierce that cloak or look beyond it to determine whether or not the conduct that was done was official or unofficial. And then there's a last kind of classification, which is private conduct like Donald Trump, for example, as a candidate who had lost in November of 2020, trying to overturn the election results of that 2020 election. Private conduct is not immunized. Again, that also is not a new legal concept. The really kind of quick takeaways, Alex, that people need to remember are twofold. One, the idea that evidence cannot be used in the course of a prosecution of that official act conduct, meaning if Donald Trump is to make a speech about how he wants to overturn perhaps or get rid of a political rival, the existence of that speech cannot be used as evidence, but perhaps the fact that he was a candidate at the time would be unofficial, and that could be not immunized conduct, and it could be used as evidence. And so the official acts evidence cannot be introduced in the course of a prosecution. And the other kind of takeaway is the fact that now there's extra work that needs to be done by a judge, Alex. Now a judge like Tanya Chutkan, or for even, Eileen Cannon in Florida, those judges have to make those preliminary assessments whether or not certain conduct is official or unofficial. And so, again, there's a lot of takeaways from it. But no, it is not total exoneration.
OK, three more questions for you, Katie. So the implication here, listening to you, evidence in each of Trump's cases can now be thrown out. That's one. Can he get the classified docs charges dismissed? And lastly, does the ruling give him grounds to appeal the hush money conviction?
Wow. OK, so the hush money conviction, we know that he's challenging it because the fact that certain official, or what he calls official acts evidence, was being used. Judge Merchan is allowing them to brief that. We should get a ruling at the beginning of September from Judge Merchan. But if it occurred not while Trump was in office, if it occurred, and I don't mean physically, right, because I'm not talking about the fact that he was in the Oval Office signing these checks to Michael Cohen at the time. I'm talking about the conduct, the underlying conduct, as long as it wasn't when he was serving as president. And more importantly, it's not just temporal. It's not just timing. It's not just he was holding the moniker of president. It's, was he doing it within kind of like his duties? That's kind of this idea that you're operating within a sphere of conduct, Alex. Was that happening? I mean, that applies across the board now. That is in Florida. That is for fake electors. That is in New York, Alex. And that's really the conduct there.
So classified docs, those charges could be dismissed then? Because you mentioned Florida. It's all Mar-a-Lago stuff.
Well, so that's why Chutkan's going to have to do this analysis. It's whether or not the conduct of Donald Trump was occurring. And was that official? Was it a part of his official duties as president of the United States to be able to steal and retain classified documents? I would submit to you the answer is no. And remember, a lot of the conduct, Alex, is what happens after he left the Oval Office. The packing up the classified documents and getting them down to Mar-a-Lago. The repeated acts of trying to get it back from him. I'm sure Trump's going to argue that it is peripherally, if not tangentially, related to his role as president. And that's what Eileen Cannon is going to have to hash out. But I will say one silver lining, guys, because I know Cannon moved really fast, Alex, on this. This motion was filed yesterday by Donald Trump. This morning, before anybody even got their day started, Cannon entered this order. If Chutkan's going to do an evidentiary hearing, Cannon's going to do an evidentiary hearing. And all of that evidence that perhaps we weren't going to hear before November, we're going to hear even in the classified documents case.
OK. So we have the Washington Post, Hugo, reporting the DOJ plans to move ahead. And if the election goes for Trump, they're going to continue prosecutions right up until Inauguration Day. What are your sources telling you about this?
This has been the position of the Justice Department for some time now. I mean, as recently as the week before the Supreme Court's immunity ruling, people close to the special counsel's team, people inside Main Justice were telling me that they saw a path for, and granted this was before the immunity ruling, they saw a path for a trial to start right before the election, and they could continue all the way through to election day. So this has been their position for some time. It doesn't surprise me that the Justice Department, is maintaining this position, notwithstanding the immunity ruling. And that's because the Office of Legal Counsel at DOJ has made it very clear that the 90-day rule, the 60-day rule, It's being interpreted in more and more kind of weird and wonderful ways these days. But the rule that says the Justice Department should not take overt actions close to an election, the Office of Legal Counsel has said definitively that is with respect to grand jury investigations. It did not apply to actual prosecutions and going to trial, because after all, that's in the purview and the jurisdiction of a trial judge.
In your latest piece for The Guardian, you argue in a potential second term, Trump would be free to abuse core presidential function without accountability. Like what categories of immunity did the court outline? Where do you see the most room for potential abuse, Hugo?
So I actually take a more pessimistic view than Katie. And this is really because, the core executive functions as the court laid out in the majority opinion is absolutely immune. And, I envision scenarios where, Trump as president in a second term could have discussions with the Justice Department to, for instance, end investigations that are into him. The example that I keep coming back to is with Robert Mueller and the special counsel. When Robert Mueller testified to Congress in 2019, it was his belief that Trump could be prosecuted for obstructing the Russia investigation after he left office. That is no longer true under the current state of affairs in this country. If there was a similar scenario, there is no way the Justice Department would be able to bring this case, bring an obstruction case, because Trump would just claim, look, special counsel Robert Mueller, he was part of the Justice Department, and the Justice Department's conversations with the president are absolutely immune. You can't introduce it into evidence, you can't charge it, and so the case would go away.
Okay, let me further this with you, Tim. Justice Sotomayor's scathing dissent invoked the SEAL Team 6 example and paints a pretty grim portrait of a commander-in-chief now, quote, immune from criminal liability. But here's what former Trump White House counsel Ty Cobb says about it. Take a listen.
You can't design a rule that is solely about Trump without putting, the democracy at risk and eliminating some of the restraints that have historically gotten us through 250 years. Separation of powers is the cornerstone of the Constitution. And as much as I wish Trump would get his comeuppance and his due for his evil conduct, the reality is you just can't go out and have a result-oriented effort by the Supreme Court.
So do you agree with that, Tim? Did the court get this right?
No, I don't think the court got the decision right. No, Alex. Look, the court was focused on posterity, right? A rule that, as Ty Cobb was just saying, sort of applies broadly to executive authority and the power of the president, not mindful of the immediate threat that Justice Sotomayor pointed out. The incentive that the Chief Justice talks about, that you don't want presidents encumbered with the threat of potential prosecution, that's a bad incentive. In my view, consistent with Justice Sotomayor, is outweighed by the incentive this creates for presidents to do things really aggressively without fear of criminal prosecution. What I think bottom line, Alex, is that the decision shifts a lot of authority to trial judges. And as Katie was just saying, in order for Judge Chutkan, for Judge Cannon to make decisions about how this opinion actually applies to the evidence alleged, they have to hear evidence. So I think what we're looking at are lengthy pretrial proceedings at which Jack Smith and his team lay out in meticulous detail by calling, I think, live witnesses what the evidence is and arguing to those judges how they believe that evidence survives the Supreme Court's immunity test. So the evidence may very well come out more quickly because of the fact that judges have to evaluate that evidence and apply the Supreme Court test. I think Judge Chutkan soon sets a scheduling order for a very lengthy evidentiary hearing at which the special counsel shows his cards, potentially calls Mike Pence, Mark Meadows to the stand in a federal courtroom in Washington before the election to give Judge Chutkan the predicate to make decisions about what's in and what's out.
Okay. Katie's nodding in agreement, just so you know there. Let me ask you, Tim, about the Biden-Harris campaign, which is drawing attention to a Trump-endorsed candidate for governor in North Carolina who told a church congregation last weekend, quote, some folks need killing. Then Tuesday, the head of the Heritage Foundation, that, of course, conservative group behind Project 2025, said this during his endorsement of the Supreme Court ruling. Let's watch.
We are going to win. We're in the process of taking this country back. We are in the process of the Second American Revolution, which will remain bloodless if the left allows it to be.
Tim, how do you interpret this violent rhetoric? And can this ruling strengthen Trump's ability to enact plans that have been outlined by his conservative and Christian nationalist backers now?
Yeah, Alex, look, all I can say in response to that is that we saw example after example during our investigation of the attack on the Capitol that people take that rhetoric literally. It's just simply not acceptable for the former president or other of his enablers to say that's just rhetorical. It's not rhetorical to a lot of people. A lot of people in the crowd at the Capitol were there because they believed the president wanted them there and that the president's invocation of you have to fight like hell or you won't have a country anymore, they took literally. So in a polarized world in which we live, in a polarized country, that kind of rhetoric, very, very irresponsible because people take it literally, not rhetorically.
Hey there, MSNBC fans. I'm Luke Russert, and be sure to join me, Rachel Maddow, Jen Psaki, Lawrence O'Donnell, Steve Kornacki, Joy Reid, and many more September 7th in Brooklyn, MSNBC Live Democracy 2024. Click on the link for ticket information. We will see you there.